Welcome everyone to the Cornerstone Planning Case Law Review, which is a rather grand title. I hope we haven't overplayed our hand. Today you'll be hearing from me, Tom Cosgrove, and my colleague Robin Green, who is, as many of you will know, a walking encyclopedia of planning case law, so we're in safe hands with him. I'm very pleased indeed that so many of you have been able to join us today. Thank you very much for logging in, and thank you also for the excellent questions we've had from many of you in advance. We'll be picking up on some of those as we go through, and trying to answer some at the end, where we're going to have a short question and answer session as well. Just some very short housekeeping matters. This is one of a number of webinars that Cornerstone Barristers undertakes, and it will be recorded and it'll appear on our website probably next week in case you missed some of it today or you weren't able to make it. We also have a number of other resources on our website that may be of interest to you. We've got planning bulletins, the newly launched Cornerstone Development Quarterly, which I was told I had to plug, and many other webinars are coming up soon. And of course, we're always open to requests for particular topics and matters to cover. There will be a short survey sent to you towards the end of the webinar asking for any feedback, and please feel free to give us any feedback on that and any suggestions for future webinars. So today, if we can go to the next slide, please, Robin. We are going to cover as many topics as we can, but we are limiting ourselves principally to the 4 areas you see on that slide. We can't cover all the areas the questions have arisen, but we hope these will be useful and topical ones to cover. And we're going to focus on the recent case law. We're going to pick up in our talk between the two of us cases that have happened principally in the last few months, and as recent as yesterday, when there was, as many of you will know, a Supreme Court case dealing with heritage. We're going to pick up on that as well. And there are 4 broad areas we're going to cover. Interpretation of policy, which I'm going to deal with in the next 10 to 15 minutes. Then I'm going to hand over to Robin, who'll deal with decision making and the tilted balance. Then I'll come back for Greenbelt, and we'll end off with heritage. And we're going to try and keep 10 to 15 minutes at the end where we can deal with questions. So if we start on the next slide, please, Robin, interpretation of policy. And next slide as well, please. I'm going to cover 2 aspects of policy interpretation, which is a particularly topical area that's been covered by the courts at the moment. The first is the approach to interpretation of a development plan as a whole in a decision-making context. And that's principally picking up on a recent case in the Court of Appeal dealing with how one should approach Section 38(6) as a decision maker. And then secondly, the issue of how one approaches the construction and application of particular planning policies, whether they be at a national or local development plan level. So next slide, please, Robin. And I thought it would be useful just to, unless of course you live in Cornwall, and some of you may live in Cornwall, but this is somewhere I'd much rather be than my place in London where I'm speaking to you from. And that is a view of the Sunhaven Holiday Park and the coastal village in the distance of Morgan Porth, if I pronounce that correctly, in Cornwall, where I'd very much like to be at the moment. And you can see there that is a nice aerial shot of the location, and that was the subject matter of the very recent, in April, Court of Appeal case of Corbett against Cornwall Council, which deals with this first issue of development plan as a whole. And it picks up on the often overlooked point of what is meant by in accordance with the plan in Section 38(6) of the 2004 Act. And as most of you will know, many decisions proceed on the basis that if one can identify a conflict with a relevant policy in a development plan, the proposal will, on the face of it, not be in accordance with the development plan, and therefore one is in the area of balancing any conflict with material considerations. But that's not quite the case, as the Court of Appeal reminded us in April in the Corbett decision. Now, the facts of the decision are fairly straightforward, and I'm pleased to report it was a resounding win or cornerstone in the Court of Appeal. It's fair to say that as we acted for both sides, we were always had a good chance of winning. But nevertheless, again, that's something else I've been asked to mention by at least one barrister in chambers. The case concerned an extension of a caravan park within a designated area of great landscape value. And the local authority's planning committee had permitted the proposed development on the recommendation of the planning officer. At the material time, the development plan consisted of both the Cornwall local plan and the Cornwall local plan as well. And there existed policies in relation to landscape, which you'll see there, policies 14 of the RLP and 23 of the CLP, which stated that development that would harm the area of great landscape value would not be permitted. And policy 23 was a more general landscape protection policy. And the key point to note is that the officer had reported there would be conflict with such relevant development plan policies in the report. However, the officer went on to note that as it complied with other development plan policy which supported tourism, particularly CLP 5, tourism being a matter of great importance for obvious reasons in Cornwall, the council, on the basis of the officer report, formed the view that it was overall in accordance with the development plan as a proposal, notwithstanding the conflict. Now, on appeal at first instance, the judge held that the planning application should have been rejected because the development would harm the area of great landscape value and therefore was prohibited by policy 14, and in effect indicated that in his view the council had been wrong in saying it could not be in accordance, wrong in saying it could be in accordance with the development plan. Now, the Court of Appeal, if we go on to the next slide, please, Lord Justice Lindblom disagreed, and the following, I think, key points can be taken from that judgment. First of all, he made the point that section 38(6) could properly be discharged only if the decision maker established, first of all, whether the proposed development accorded with the development plan as a whole. And if was the case, as is usually so, that development plans which contain broad statements of policy are likely to pull in different directions, one had to be careful of that point. And where that was the case, local planning authorities and decision makers generally had to exercise a judgment to determine whether the proposal accorded with the plan as a whole, bearing in mind the relative importance of the policies in play and the extent of compliance or breach. Applying those principles on the facts of the case before the Court of Appeal, the policies, they said, did pull in different directions, but they had to be read together. If we go on to the next slide, please. And what the court held was that although there was some conflict, it was perfectly proper, provided the policies were construed and interpreted in a correct and lawful way, which I'll come on to in a moment, such a conclusion could be arrived at. And the court was not going to intervene in such a planning judgment if it was arrived at correctly. So it's an important case. Takeaway points, as it were, what are the implications for the judgment? Well, the first one, I think, is that it is now an argument that one is likely to see pursued with vigour by applicants on appeal or at the application stage, arguing that even if there is some conflict with a relevant policy, one should still come to the conclusion that the development plan was accorded with as a whole, and in effect praying in aid, for example, para 11C of the NPPF, the precursor to the tilted balance debate that Robin's going to come on and talk to in a moment. In other words, you'll recall that 11D urges decision makers to pursue the presumption in favour of sustainable development by, quote, approving development proposals that accord with an up-to-date development plan without delay. What that does, of course, is really restate section 38(6) with a bit of policy spin. So that's the first point. You're going to see a lot more of that, I think, in applications and proofs. And of course, councils might rely on it too, as was the case in Cornwall. The second point to note, I think, though, is it does not follow from this case that a conflict with a single development plan policy can never mean there is a conflict with a plan as a whole. Lord Justice Lindblom was quite careful not to go that far. So the case does not decide that. The point is, it's a question of judgment in each case. The third point, though, it does emphasise, when you look at the judgment, how important it is that careful planning, judgments and interpretation of policy is undertaken in the context of decision making to try and prevent and preclude public law challenges being made. And finally, I think it's fair to say it doesn't really decide anything new in the sense that this principle of looking at the development plan as a whole has always been there, but it does give new life to what was a long-standing principle. After all, the judge at first instance had, according to the Court of Appeal, got it wrong in relation to what was apparently a long-standing and well-understood principle. So an important and recent case from just a few weeks ago to bear in mind. Now, I'm going to move on swiftly to the next part under policy interpretation, where I deal with policy construction and application. And I think it's just useful to pause briefly and recall the two concepts that the courts have particularly been promoting in the last couple of years as being critical in planning challenges. The first is the concept of construction or interpretation of policy. And the important thing to note there is that when you're looking at a policy, the decision maker must understand and identify what the relevant policy is and what it means. And what a policy means is a matter of law, and there is only one true meaning to it as a matter of legal theory. One has to contrast that against the concept of applying policy, and that really means that once the policies have been understood and interpreted, how one applies them in the making of decision, the application of them, is entirely a matter for the exercise of reasonable planning judgment, and the court is unlikely to disturb a reasonable exercise of such planning judgment. Those two concepts are critical in understanding why cases go various ways, and I would respectfully suggest critical when one is considering making a challenge or describing the way you put a case or defend a case, whether you're an applicant or a local planning authority. Next slide, please. And a useful illustration of these concepts comes in a number of recent cases. The first one I wanted to flag up to you was a case you may have heard of, the Gladman and Canterbury Court of Appeal decision. And in that case, before one just looks at the facts, it's useful because it highlights 5 points that I've identified in these slides, which are relevant to how one should construe policy, whether that be national or development plan policy. And I've set them out briefly there. The first is that the court said, again, Lord Justice Lindblom, the interpretation of a development plan policy is ultimately a matter of law for the court. So far, so easy. Point 2, the court does not approach that task with the same linguistic rigour as it applies to the construction of a statute or a contract. That pause there, that is something to bear in mind. One can't just reach for your textbook on how you construe a contractual provision when you're trying to understand what a policy means. And it can be quite a different context from that one is used to in applying and interpreting statutes or contract. The third point is that the court said what one must do is seek to discern from the language used in formulating the plan what is the sensible meaning of the policies in question in their full context and thus their true effect. That's the search for the one true meaning point. Pausing there, that could be quite an intricate exercise. It all depends, doesn't it, after all, on what the context is. Next slide, please. Point 4, the context, according to the Court of Appeal, includes the objectives to which the policies are directed, other relevant policies in the plan, and the relevant supporting text. So that's quite a broad context, which will differ vastly, I would suggest, from case to case. And finally, the court will always keep in mind that the creation of development plan policy by a local planning authority is not an end in itself, but a means to the end of coherent and reasonably predictable decision-making in the public interest. So again, we go to the next slide. I would suggest that there is, the problem there, if there is a problem, is that it allows quite a fluid interpretation of what context means. And it is inevitable, and this has been demonstrated by what has been happening, that there is scope for differing interpretations, even amongst seasoned professional lawyers and indeed judges. And this has been going on for a couple of years now. You only have to look at the amount of cases where the High Court has been overturned by the Court of Appeal and the Court of Appeal has been overturned by the Supreme Court on points about interpretation. So it is likely to lead to continuing extensive litigation. And remember, the Cornwall case reminded us that the interpretation of policy depends on reading language in context, but the distinctions can be very fine indeed. You can go to the next slide, please. And that's because context is so fluid. Now, one can illustrate this by just reminding ourselves that in Canterbury was a case that concerned policies in the context of a residential development on a greenfield site outside a village settlement boundary, so a very typical and normal case. The policy context there was that the policies in question were permissive in that they identified areas where housing could go, but they didn't specifically say housing couldn't go in other areas. But the court, when it was interpreting that policy context, said the proposals that didn't get explicit support in that context by necessary inference were contrary to the development plan as a whole. So that was one approach. And you can compare that with the Chichester case, where in Chichester, the provisions of the local plan, which again were similar, one might think, to in Canterbury, but the court there said that there was no such inference that was required because the policies of central relevance to the proposal were construed as being explicit in that case. Next slide, please. So there is a great difference, and there's a potential difficulty, I would suggest, in approaching these matters. It's a difficulty highlighted when one looks at the Chichester judgment and the Canterbury judgment. In Chichester, as I've said there, the correct interpretation resulted in the policies requiring no such inference because they were explicit. But where does this leave us all? It leaves us, if you just pause and think about it, after Cornwall, it is quite possible that you can have a conflict with a relevant policy in a development plan, a relevant policy, and not be in conflict with the development plan as a whole. But on the other hand, it's also possible, following Chichester, that you won't offend or conflict with any particular term in a policy, but nevertheless be in conflict with the strategy in it. See Canterbury and Chichester together. So next slide, please. And you can see that from the quote, I just put a quote in there from Lord Justice Lindblom in Chichester referring to Canterbury in the earlier well-known case of Crane on his take on what Canterbury showed. And you'll see that the second bit in bold I've highlighted, and this is the crux of the matter, whether this is, he says, so will always depend on the particular context and critically the wording of relevant policies, their objectives and their supporting text. So it all comes down to context. And just the final, as it were, kick in the teeth for litigants and lawyers, don't forget that amidst all this, as well as the courts and the High Court judges and Court of Appeal judges disagreeing with each other on interpretation, the courts have constantly put forward the refrain with, as I say, almost a sense of despair that litigants should be very careful when they're dealing with concepts of construction and application and avoid excessive legalism. And that is rather rich, with my respectful submission, when you see some of the judgments and disagreements about context and legal interpretation that one sees in the judgments. Next slide, please. And I'm just going to end my section before I hand over to Robin on a recent example of these concepts of policy, construction and interpretation in action, provided just a few days ago in the High Court by Mrs. Justice Leven in the Wiltshire Council case from the 23rd of April 2020. And that was a case when we were well into lockdown. It was conducted by video link on Skype because of the coronavirus pandemic. And it concerned the interpretation of para 79D, in particular the NPPF. And I'm sure you all know that's the part of the NPPF that now deals with development of isolated homes in the countryside. And in particular, the case dealt with the meaning of what was meant by, quote, subdivision of a residential development, a residential dwelling. The issue in the case was whether the subdivision had to relate to one physical dwelling, and the inspector had said no, having interpreted what the inspector felt 79D meant. But the court said yes, and at para 26 of Mrs. Justice Leven's judgment, which if you have time, it's worth going to look at. She looked at the arguments and said that the starting point, in her view, was that the meaning of dwelling within the paragraph is, quote, a question of interpretation of policy and not its application. And so she there was picking up on the recent case law and distinguished from the outset of the case what the issue was. It was not an application case, she said, it was a policy case. And when I come back after Robin and we talk about Greenbelt cases, you'll see how the court have turned their head on that and dealt in the Greenbelt context very much on the principle of application rather than policy construction. So the issue in the case, she said, was not whether the word dwelling was reasonably capable of carrying the meaning given by the inspector. That was not the issue. It was whether what was given to it was the correct meaning, whether it was the one true meaning in law. And Mrs. Justice Leven said the inspector had got it wrong. So it's a good example of how the interpretation of a particular policy aspect was determinative and a good example of how the courts are approaching things at the moment. So I think that's the end of my section, Robin. And I'm now gonna hand over to Robin to deal with the next part.
Thank you very much, Tom. Yes, I will deal with decision-making and the tilted balance. I've set out the three topics that the case law I'm going to look at covers, but I'm not going to go over the recap in any detail. I simply refer to the content of paragraph 11, 11C, Tom, you've already referred to. In short, the result of all of that, before you get to the tilted balance, is that if development or a development proposal does not accord with the development plan, permission should be refused unless material considerations indicate otherwise. And it's in paragraph 11D and the tilted balance that one has an important and indeed very often decisive material consideration that can justify a departure from the development plan. I've set out in this slide the content of paragraph 11D for those who have the time to go back over this presentation. One can see that very much in summary, the tilted balance is applied where there are no relevant, up-to-date development plan policies, unless either there are specific protection policies in the framework that say otherwise, or unless the adverse impacts outweigh the benefits. The case law has considered a number of aspects of the tilted balance. There are two triggers to its application. The first is where there are no relevant development plan policies at all, and the second is where the policies which are most important for determining the application are out of date, and helpfully or not, depending on your view, we have a case law in the certainly last 12 months that cast light on the operation of both those triggers. The first case, Paul Newman Homes, was a case where the first trigger was considered, where there are no relevant development plan policies. I'm not going to look at the facts summarized in that slide. I'm going to go straight to the next one to see what Sir Duncan Ouseley said about the question, what does it mean where there are no relevant development plan policies? Taking the approach that the courts have increasingly been taken of looking at the plain meaning of the words, he said the phrase itself is clear. Where one or more relevant development plan policies exist, the first trigger simply doesn't apply. One relevant policy is enough. It doesn't have to be an up-to-date policy. An out-of-date policy will do. And what is relevant means that simply means having some real role in determining the application. So a fanciful connection is not enough, but it certainly doesn't need to be an important policy for it to be a relevant policy, and a standard development control policy could be a relevant policy for these purposes. I should say that decision is going to go to the Court of Appeal in the next month or so, so we'll get the Court of Appeal's view on that relatively shortly. As to the second trigger, where the policies which are most important for determining the application are out of date, we have two decisions of Mr. Justice Dove that cast light on that. The first case is Wavendon, and that's useful in identifying the overall approach to identifying whether this trigger applies or not. Again, the facts aren't hugely important. The approach identified as correct by Mr. Justice Dove is this: you decide which policies are the most important for the determination. That's a matter of planning judgment. You assess whether each is out of date, applying the NPPF and Bloor-Holmes. That's either a matter of fact or a matter of fact and judgment. And finally, you form an overall judgment as to whether the policies as a whole are out of date. So you have your basket, you put in the basket the most important policies, you assess them individually and then collectively. Moving on to the next case decided by Mr. Justice Dove, what is meant by out of date? That case concerned a wholesale challenge not simply to the relevant policies, but to the development plan itself. That was the City of Salford UDP 2004 to 2016, adopted in 2006, so a time expired plan. The housing requirement in it was based on RPG 13, which came out in 2003. The plan was produced within a very different policy context, and the local authority had accepted similar housing schemes elsewhere on greenfield sites. And it was said by the appellant in that case, not only are individual policies out of date, but the whole plan is out of date. The Inspector and Secretary of State disagreed, and Mr. Justice Dove held that the Inspector and Secretary of State were right. Whether a policy and indeed a plan is out of date is a matter of fact and judgment, that's well established. The NPPF does not say that the expiration of the plan period means the plan itself or policies in it are out of date. What is crucially important, I suppose broadly two matters. The first, consistency with the NPPF, and the second, whether the policy or policies in question are delivering on the ground. In that case, the policies in question, environmental protection policies, recreational protection policies, they remained consistent with the NPPF. Their objectives remained relevant to the local area. The plan itself was delivering an appropriate quantum of housing. There was a 5-year housing land supply. And overall, the approach of the Inspector and Secretary of State to look at consistency was the right one. That case too is going to the Court of Appeal in a month or so's time. So again, we will get the Court of Appeal's view on whether that is correct. So those were the triggers. Then we come to applying the tilted balance itself. And as we know, that calls for the grant of planning permission unless one or other of two provisos are satisfied. The first is that there are certain protection policies in the NPPF, and if they're applied and if they provide a clear reason not to grant permission, then permission should not be granted. And the second is the well-known adverse impacts versus benefits balance. Both those provisos have been considered recently by the courts. The first case, Monkhill, is quite a specific case concerned with policy on the protection of areas of outstanding natural beauty. AOMB policies are part of the policies identified in footnote 6 to the NPPF as being one of the protection policies which may engage the first of those provisos, in other words, disapplying the tilted balance. That was a legal challenge which plainly found disfavour with the court, being, it was said, a highly artificial legal challenge. Paragraph 172 of the NPPF says that great weight should be given to conserving and enhancing landscape and scenic beauty in AOMBs. But within that paragraph, there's no test, there's no balancing exercise. And it was said by the appellant in that case, that particular paragraph couldn't provide a clear reason not to apply the presumption. If one looks at it, all it does is require that weight be given. The inspector disagreed, he said that applying paragraph 172, that did provide a clear reason for refusing planning permission and for disapplying the presumption in para 11D. That was challenged in the High Court. Mr. Justice Holgate criticised the challenger in that case for adopting a legalistic argument. He said, don't be silly. In para 172, the very fact that you're requiring the decision maker to apply significant weight means that a balancing exercise is involved. And if the balance falls down against the grant of permission, that is a clear reason for refusal. That case too is going to the Court of Appeal in November this year. As to the second of the provisos, the adverse impact versus benefits balance, the question raised in the Gladman Developments case recently was whether in carrying out that balancing exercise you look at simply the framework policies and that's it, whether you also take account of potentially breaches of the development plan as well. Mr. Justice Holgate answered that in the Gladman case. Again, I've summarised the facts on that slide, but they're not hugely significant. What matters is the decision. And in short, Mr. Justice Holgate said that in carrying out that balance, you do take account of development plan policies as well. And he criticised the appellant for adopting excessive legalism in the approach taken. Right, that's the end of my session. I'm going to hand back now to Tom.
Thanks, Robin. Concise and erudite as ever. Back to the more generalised blurge from me. And I'm going to turn to Greenbelt. And I'm going to cover two aspects. You can go to the next slide, please, Rob. The first covers the approach to exceptional circumstances as a test in a policy plan-making local context. And the second concerns the recent Supreme Court case from February dealing with the issue of openness. That's the Samuel Smith case from the 5th of February in the Supreme Court. And if we can go to the next slide, please, Robin. So far as the first case is concerned, useful, I hope, to deal with this. We've had a number of questions about the approach to exceptional circumstances. Victoria Yandel from Barton Wilmore and I think Charlotte Taylor-Drake, who I both think are watching or at least pretending to watch this webinar, are asked questions on this, so I hope it's useful to address it. And the case of relevance now is Compton Parish Council against Guildford Council, and that was a case dealing with a challenge to a local plan. And the court held that the local plan was not unlawful, where there were, in the circumstances, exceptional circumstances that justified the release of land from the Greenbelt to meet the area's objectively assessed need for housing. There are a lot of issues dealt with in that case. I'm just going to focus on the Greenbelt issue. Gratuitous plug coming up. I've been forced to do this. It was a cornerstone win. James Finley and Robert Williams, a terrifying combination, succeeded, and I mean that in a good way. So the case concerned a challenge to a local plan. Now, points I think to take from the judgment of Sir Duncan Ouseley on exceptional circumstances, and I'm sure like many of you will have sat through many local plan examinations when one trawls through the test relating to exceptional circumstances, and from the judgment in Calverton, Mr. Justice Jay, and there's lots said about it. And Compton provides some useful guidance, I think, going forward. A number of key points to take away from that, from Sir Duncan Ouseley's judgment. If we can go to the next slide, please. The first point to note, as he made clear, was that there is no definition of the policy concept of exceptional circumstances, and that is deliberate. It's deliberately not defined, and it demonstrates that there is a planning judgment to be made in all the circumstances of any particular case. Now, a planning judgment is required, and you can see I put a quote there from Sir Duncan Ouseley, which illustrates that point on the slide. And he did note, going back to our discussion earlier about the difference between a policy interpretation as a matter of law and an application, he did say that, of course, at least in theory, the meaning of an exceptional circumstances as a matter of law. But given the wording, the deliberate, as it were, fuzziness of the concept, he took the view, I think quite correctly, that didn't really take one very far, because a judicial decision that a factor relied on by a decision maker as an exceptional circumstance was not in law capable of being one, was likely to require, as he put it, some considerable caution and judicial restraint. I think he's really saying this is the kind of case where you need to apply planning judgment rather than legalistic concepts. And as you see from that quote, when you're looking at the concept, all that is required, as he says there, is that the circumstances relied on, taken together, rationally fit within the scope of exceptional circumstances in the context. He's really making the point in that quote about application rather than interpretation. Next slide, please. The next point I think to take from the judgment is that exceptional circumstances, he made absolutely clear, is a less demanding development control test for permitting inappropriate development in the Greenbelt than that one finds in very special circumstances. And that difference, he says, is clear from the language itself and the different contexts in which they appear. And he set out various authority for that proposition, as he put it, if it was really needed. And the next point to note is he made clear that one can really fall into the trap of over-analysing what is meant by exceptional circumstances. As he put it, there's a danger of what is a very simple question of whether there are exceptional circumstances or not being over-analysed. He was really having a go, I think, at lawyers rather than judges. He says, for example, he doesn't want to hear arguments, or the court shouldn't hear arguments, that at least more than one individual exceptional circumstance is required because of the plural. That's not the case. Exceptional circumstances can be found either singularly or in the accumulation or combination of circumstances of varying natures, which entitle decision makers in a rational exercise of planning judgment to say that circumstances are sufficiently exceptional to warrant altering the green belt. Next slide, please. He also made the point in relation to housing that it's quite possible for ordinary housing to constitute something that can lead towards a finding of exceptional circumstances. That you don't need some kind of unusual form of housing or a particular intensity of need to justify a planning judgment that there are exceptional circumstances that exist. And then in relation to Calverton, he referred to it and said, well, what one's going to appreciate about the Calverton checklist, as I say, one sees rolled out in local plan examinations, is that it is not something you have to deal with in every case. All the points are not always going to be relevant in a particular case, and others may be more important that are not on the list, especially, as he noted, in the context of the overall distribution of development and the scope for other uses to be provided for along with sustainable infrastructure. So that's an important point to note. And I think the final point on Samuel Smith, so far as Greenbelt and exceptional circumstances, is to note that the court really stamped down on attempts by one of the legal parties in that case, not the Cornerstone team, I hesitate to add, that there should be some approach to defining exceptional circumstances as a matter of law. The court was quite clear that though what is required in this context is not an interpretation point, but a planning judgment point. So you can contrast that quite readily with the approach that Mrs. Justice Leven was taking in the Wiltshire case I referred to earlier, where interpretation was the key that unlocked that case. In the context of exceptional circumstances, that is not the way forward. It's a planning judgment. That is the key point to bear in mind. So I think that's enough on exceptional circumstances in the Compton case. Then the Samuel Smith Supreme Court case from just a few weeks ago. And that case concerned the meaning of openness in the Greenbelt in the context of what was formerly paragraph 90, now one finds in the same terms in para 146 of the NPPF. And as one readily knows, and I imagine most of the listeners know, certain forms of development are not inappropriate in the Greenbelt, provided they preserve the openness of the greenbelt and don't conflict with the purpose of including land in the greenbelt. In the particular case, they concerned a quarry operator who'd applied for planning permission for a 6-hectare extension of a site situated in the greenbelt. The planning officer had looked at a wide range of planning considerations, including potential landscape impacts, and concluded that the proposed development preserved the openness of the greenbelt, and planning permission was granted, but subsequently then challenged by way of judicial review on the basis that the planning officer had failed to consider the visual impact of the development. And it's a good example of how different levels of the judiciary can vehemently disagree with each other. The High Court found effectively that the visual impact was not a relevant consideration. The Court of Appeal, Lord Justice Lindblom, disagreed, and so they came to different conclusions. The Supreme Court held that the visual impact of the proposed development was not, in essence, a necessary part of the openness assessment. In other words, on the issue of openness, a decision maker may, but not must, consider visual matters as well as, of course, spatial effects. We can go to the next slide, please. And you'll see there I've set out that, in fact, we can just go one slide back, actually, please, Robin. So I've set out in that slide how the High Court decided matters and the Court of Appeal decided to the contrary. And there's a useful quote, I hope, from the Supreme Court judgment on what they found on that particular element. So that's one upshot from the case. In other words, that openness is a matter of planning judgment. It falls rather like exceptional circumstances. Whether openness is relevant is a matter of planning judgment and not a matter of law. So similar, in one sense, to the approach by Sir Duncan Ouseley in relation to exceptional circumstances. Of wider interest, perhaps, from the Supreme Court cases, the approach the judgment took to material considerations, planning material considerations. Lord Carmouth provides an interesting judgment on this, and where he quite vehemently disagreed with Lord Justice Lindblom. And in essence, when you look at it, you'll see that it was held that a material consideration is only required in planning decisions to be taken into account where either it is required as a matter of legal obligation to be taken into account, or the facts of the case mean that it was, quote, so obviously material as to require direct consideration. So I think that's perhaps a more interesting and broader application point to take from the Supreme Court, whether a permissible or material consideration is taken into account is a matter now of planning judgment and not a matter of law. See it particularly the judgment of Lord Carmouth. Robin, I'm going to hand back over to you.
Thanks, Tom. I'm going to deal with the last topic today, or the last collection of topics under the banner Heritage. I've listed them there. Essentially, how far does one have to go to show that what is proposed is the optimum viable use of a heritage asset, or is enabling development that is acceptable, albeit contrary to the development plan. Then there are various sort of subtopics concerning harm, benefits, and whether or not one can question the listing of an object as a listed building. Going straight on to the first of those topics, that brings me to the case of Bramshill. In that case, there were development proposals, and a whole host of development proposals concerning a number of listed buildings and a registered park and garden. And one of the proposals was for extensive residential development within the registered park and garden, it being argued by the appellant at the inquiry that constituted the optimum viable use of the park and garden, and or it was enabling development, allowing the park and garden to be maintained and improved. The inspector disagreed. She had concerns about various aspects of the proposal, and she said that she wasn't persuaded that there isn't a less harmful residential scheme that could be provided with the same benefits to the registered park or garden, although there was no such scheme before her at the time. The developer was unhappy with that for various reasons. First, there was no scheme. No one suggested a better scheme at the inquiry. And second, the inspector hadn't given the developer any inkling that that was the way she was thinking. That came before Mr. Justice Waxman. He rejected that aspect of the challenge and others. He said that unlike in ordinary cases where you have development that potentially affects a heritage asset, the possibility of less harmful development is a matter of particular importance. And a decision maker is not obliged to hunt around for a specific scheme as an alternative. A decision maker can take the view that the scheme before her is deficient in a number of respects, and that there is a prospect of a better scheme coming forward. On the facts of that particular case, the inspector's concerns about the scheme were so significant that even if she had told the developer, it wouldn't have been possible to make minor modifications to the proposal, keeping it within the bounds of what was before the inspector. A more radical rethink was required. And so in that case, Mr. Justice Waxman said that the inspector didn't need to disclose her thinking before she issued her decision letter. There was another argument by the appellant. It was said that in that case, there were both benefits and disbenefits arising from the proposed development. And before you need to apply NPPF policy on heritage, you should carry out some sort of internal heritage balance and only apply heritage policy if the balance showed that there would be some residual harm. That was rejected by Mr. Justice Waxman. He said, no, if there is harm, whatever the benefits may be, you must apply heritage policy in the NPPF, not least because that is the way in which a decision maker discharges the statutory duty under section 66 and 72 of the Listed Buildings Act. Finally, the other aspect of interest, the inspector in that case gave significant weight to a development plan heritage policy, even though the policy itself didn't contain the sort of balance that we see in paragraph 196 of the NPPF concerned with less than substantial harm. And Mr. Justice Waxman said that that was a permissible approach because first, it was a matter of planning judgment for her, and second, given the statutory obligation to give special consideration to the conservation of listed buildings, there was nothing wrong with having a development plan policy that in effect said the same thing. That isn't the last word. That case is going to go to the Court of Appeal at the end of this year. The next case I can take quickly, that case raised the issue of whether or not there was a further category of harm, not substantial harm, not less than substantial harm, but either minimal, de minimis, negligible, whatever. And in that case, the judge said no, any harm, however small, brings into play NPPF heritage policy and constitutes less than substantial harm. Tower Hamlets, that was a case very much on its own facts, whether or not in looking at the public benefits of a proposal, you could take into account not benefits directly arising from the proposal itself, but speculative future benefits. In that case, the development was the demolition of cottages that contributed to a conservation area. The proposal itself was simply the demolition. It was argued by the appellant in that case, well, there were good prospects of residential development coming forward on the cleared site, and that was something that should be taken into account. Mr. Justice Carr, with some misgivings, accepted that. He said if the proposal is demolition of existing buildings, the inspector can properly take into account benefits likely to result from the site being vacant. I have concerns about that from a heritage perspective, which are set out in that slide. And then the last case, that of Dill and the Secretary of State, a decision of the Supreme Court handed down yesterday. Short point, where a building or indeed an object is included in the statutory list of buildings of special architectural historic interest, can you challenge that status either in an enforcement notice appeal or otherwise? Every court up to the Court of Appeal, and including the Court of Appeal, had said no. The Supreme Court disagreed. Lord Carnwall said, no, you have the right to challenge the status of a building if included in the list, if, for example, you're being prosecuted or indeed you're the subject of a listed building enforcement notice. And finally, of also some significance, he said that in determining whether an object or item is a building, you should properly apply the Skerritt's criteria from the case concerning that large marquee. You look at size, permanence, and degree of physical attachment. That's a very brief rundown of the latest heritage cases.
Great. Well, Robin, thank you. And that really was hot off the press. We're going to just the final few minutes, like all good advocates, we're going to end on time, Rosewell trained as we are. And the good news is that there was only really one question when I looked at the Q&A box a minute ago from my old friend Andrew Croft, who I haven't seen for ages, who asked, was the sound quality breaking up? And I managed to answer that one. We both agreed it was his dodgy Welsh internet connection rather than any cornerstone problem. So that was an easy one. There was one other question I thought might be worth addressing, which was from Paul Lewis, who raised the issue of whether, given the COVID situation we find ourselves in and maybe in for some time to come, is there likely to be a relaxation in the application of the tilted balance if local planning authorities cannot demonstrate a 5-year housing land supply because of COVID? I'll just give you my thoughts, and Robin might want to add or not. I mean, it's already, people will have seen there have been a number of inspectors' decisions which have relied on the COVID factor to determine there isn't a supply, and it's clearly being taken into account, particularly in the context of deliverability when one's talking about supply. It strikes me, my view would be that it's not going to affect the application of the tilted balance in the sense of it being applied because of one of the triggers that Robin's taken us through. But one might see an increase in the kind of arguments that used to be run and which was set out most usefully in the 2013 case of Huntston Properties, which some of you might be familiar with, in the Court of Appeal, which was a case concerning greenbelt, very special circumstances and supply. And the argument was run there that even if you haven't got a 5-year supply, the decision makers really got to look at why that's the case. In Huntston, it was the case because it was inevitably going to be the case because of the particular amount of land or unavailability of land in that district because of greenbelt and other matters. But it seems to me that a decision maker could say now, well, I accept you haven't got a 5-year land supply, but that's only really because of the COVID situation. And therefore, that really is not going to affect the weight very much, or not. So it's going to come to weight, I think, rather than the application per se of the tilted balance. But Robin, do you have any thoughts on that?
Well, it seems to me the answer is going to be political. After COVID, the government is going to want to promote house building and economic activity generally as much as it can. The tilted balance helps house builders, and so the government isn't going to get rid of it or water it down. That seems to me to be the political answer anyway.
Yes. Now, Robin, I want another question's come up, I think, from Claire with respect to the case involving the subdivision of a dwelling in the countryside. I think that's the Wiltshire case she's referring to. Quite concerning, she says, does this open the floodgates for all outbuildings to be turned into dwellings in areas outside of the seven boundaries? I don't think it does open the floodgates. Claire is my short point to that. It's quite a specific case, which in fact I think limits the interpretation of the meaning of residential dwelling. And you see, this is Justice Leven's judgment to just a single dwelling rather than further. So I don't think it will open the floodgates, would be my view on that. Robin, have you got any other thoughts you want to add?
No, I think that's right. Although it's an interpretation by the court that will be a general application, I think on the facts it was quite a specific case. I don't think it's going to open the floodgates to that extent. I see there's a further question, I think, following up from your remarks.
Yes.
About how one justifies, I suppose, how would an applicant or appellant argue that the 5-year housing land supply shortfall was more affected by COVID and was not inherent? I suppose that must depend on the facts and on the evidence.
Yes, absolutely. And of course, remember, it'll apply to the scheme before as well, the scheme being pursued. It's no good for an applicant to say, well, there's a lack of 5-year land supply because of COVID. That'll apply presumably to the likely deliverability of the application before the council or on appeal as well. So it can be quite a circular argument. But I think the broad answer, it'll be a matter of weight for the decision maker. So I think, Robin, just to keep to our timetable, we're going to end there. And as I say, thank you very much for the large number of people that have joined. It's very good of you to do so. If there are other topics you'd like us to cover or other members of Chambers to cover, do let us know in the feedback. And there will be a recording of this on the website probably early next week. If there are any other issues, do let us know. But thank you again for joining us, and we hope it has been of some use to you at least. Thanks very much. We'll end the webinar there.
Thanks.